My name is Kim. Um, our company AMSI is one of the sponsors for this month's appreciation educational sessions. And today I wanted to just take a few minutes to tell all of you about our services so that we can possibly be a resource for you and your clients. We have been in the rental and property management business for many, many, many years. We're basically celebrating our 50th anniversary. So at this point in time, we've seen it all because we've done it all. And I just wanted to, again, let you know about our services because I realize that some of you don't want to get in the rental business. Some of you do help your clients with both real estate and rentals, but some of you don't want to get involved in it. And I just want to let you know that we're happy to, again, be a resource to you and your clients. The other thing is that we've been offering free rental comps for many years. And so what that means is if you have a client who's trying to decide, you helped them purchase a property, say years ago, and now they're thinking about renting it, we'd be happy to provide rental comps at any point in time. So you can just send them to me, give me a call, or shoot me an email, describe the property, give me the address, and I'd be happy to provide free rental comps. The other thing I thought I'd mention is that we have been specializing for years, primarily in condos and homes, but we certainly will do apartments too. And so with the properties that we get, it could be anything from, a studio condo that rents for $2,500 a month up to a large house at St. Francis Woods that rents for $15,000 a month. So we do all of it and all prices and all sizes in between. We certainly do apartments too, though. So we sit on the corner of Van Ness and Lombard. So primarily we're in the city, but we also cover Marin County, East Bay, and Peninsula. So I just thought I'd kind of tell you where our areas are. We do not do the South Bay. It's just too far for us to go. So the other thing is we've been a member of the SFAA for many, many, many years. And we use that organization all the time for all the tools of our trade. And we're very active with that organization. So we try to do our best to keep up on fair housing laws, the rental laws, all of that. And we use the big, thick SFAA lease, which I think is bigger and longer than your contracts. But either way, I think that's it for now. I just wanted to, again, be a resource to you folks out there who don't want to get involved in the rental business. We'd be happy to take it off of your plate. So that is it. Thank you so much for letting me speak today. And I would like to next introduce our speakers. We have Jeffrey Wu and his associate. And Jeffrey, I think at this point in time, or Jeff, he's been very active with the Association of Realtors, and he will be speaking about working with people that want to buy or sell where there's renters living in the properties. So with further ado, I pass everything over to Jeff.
Thank you, Kim, and thank AMSI. I thank them for their sponsorship. We really appreciate it. Good morning, everybody. I see on the list of attendees many, many names that I know, and so I thank you for attending. I'm here with Adrian Sarcharski, my new associate, and we are going to be presenting to you some topics that hopefully it will be of interest to you and will be useful in your practice. And then we're going to save some time for questions if you have them. Maybe you can put them in the chat, or I'll leave it to Genevieve to figure out how we can do that. But I'm going to start off with tenant buyouts, probably one of the more important subjects that you guys deal with. So I thought I'd start out in that sense with a brief primer on tenant buyouts, particularly in San Francisco. But what I'm also going to tell you applies to Oakland, which has a very similar rule. San Francisco and Oakland have buyout ordinances. And so what it requires to begin with is that we provide the tenant with a buyout disclosure telling them their rights. Now, this is just a form from either Oakland or San Francisco, fill in the blanks. We just mail it to them. And once we've done that, then we file a declaration with the rent board of the jurisdiction, just basically telling them that we've done that and who we are and who the tenant is. Once we've done that, under both these ordinances, now we have the right to start talking to tenants about a buyout. And if we can come to an agreement with a tenant on a buyout, there is certain requirements that have to be in the buyout agreement. So one of them is that in San Francisco, there's a 45-day rescission period. It can't be waived. There may be ways of getting around it, but it can't be waived. And for that reason, that creates certain structures that have to occur in the buyout agreement, particularly when we pay them. Oakland is similar, that it can be as little as 15-day rescission period. The big thing about the rescission period, and this law has been in effect for it's come on like 8 years now. I've never actually seen a rescission, but it legally could happen. And because it can legally happen, we don't pay the tenant any money until the 46th day. Otherwise, if we pay them and they rescind it, we're going to have to chase them. And so a typical deal works where we pay them half on the 46th day, assuming no rescission, and half when they leave. Beyond that, there's a questionnaire in both Oakland and San Francisco's ordinance that has to be filled out as part of the buyout agreement. The most important questions in there in San Francisco, the most important question is, do you claim to be a disabled or protected tenant? And there are 4 answers: yes, no, I don't know, or I don't want to say. We're good with any of those answers except for yes, unless it's a single family home. Why? Because if the tenant claims to be elderly or disabled, and we do a buyout, you would lose the right of condo conversion if it exists. And so for that reason, since we're usually paying a premium, we are requiring as a condition of entering into the agreement that they check anything but yes. Oakland has a similar provision in their questionnaire. And they also make us certify, interestingly, that the landlord, whether or not the landlord has made a threat of eviction as part of the discussion for a buyout. It's not clear why Oakland wants this information, because we've kind of tracked this down with Oakland. We've talked to their rent board, their city attorney, and they can't really answer what the result is of checking yes. If I write a letter to a tenant saying, I'm going to Ellis Act you out, but if I can buy you out, I'd prefer to do that, and they say yes, and we work out a deal, and no Ellis Act papers have ever been filed, does that create some kind of restriction on the property in Oakland by the fact that we had to sign under penalty of perjury that we did threaten the Ellis Act? The answer is we don't know right now. It does not seem to be, but that's one of the open questions that exist in Oakland. There isn't such an open question in San Francisco, thank goodness. So we're pretty good there. The other requirements of the buyout ordinances in both cities is that if a deal is made, then the buyout agreement itself has to be filed with the city within a certain time, and then it becomes a public record. Interestingly, in San Francisco, if you go onto the rent board's website and you click through tenant buyouts, it can lead you to a database of all the buyouts that have been registered in the city. And tenants often are very interested in this because you can, as an example, sort that huge database by zip code. And so let's say you sort it by your zip code and you find that the average buyout price is $100,000. And so often this information comes back to us like, well, the average buyout is $100,000. I invite you to go look at that. It is kind of interesting because the other thing that it'll tell you is that the high and low are extremely wide. You know, you might see a buyout for $5,000 and one for $350,000. So the average buyout isn't very telling as to what it's worth. And as I like to tell all my clients and you realtors, that in my opinion, there is no per se going rate for a buyout. Why? Because there are no competing buyers or sellers. If I'm negotiating with a tenant and they want $1 million and I say no, they have no place to go but me. There's no one else that will buy them out other than the owner. And the same thing goes for me. If I'm unreasonable, if I'm only willing to put up $2,000 for a buyout and they say no, I have no other place to go to buy out that tenancy. Unlike, you know, the sale of real estate, there are not competing buyers or sellers for tenancies. And so that creates a very different atmosphere in terms of negotiations. What I like to tell tenants is that when they present to me the database on buyouts is that if you look carefully on the database, the margin, the high and low is huge. And also the data of what you get doesn't tell you a lot, like how much rent was each tenant paying. You know, I can generally, if I had 2 units that were exactly the same size, maybe even in the same building, but one tenant moved in 10 years ago and one tenant moved in a year ago, their rents are going to be drastically different. And I can assure you that the tenant that pays well below market is going to require me to pay them a lot more money to buy them out than the tenant that's paying market rent, because obviously the tenant is paying market rent can pay market rent somewhere else. And so they're not going to need as much money or require as much money to move if they're agreeable. I wanted to talk just a little bit about recent trends that we're seeing in terms of buyouts. You know, it's a very dynamic situation when we negotiate these things, but what we're seeing is obviously it's a much more favorable tenant market. We have higher vacancy rates, rents are going down. I keep seeing news articles on my Apple News feed telling me about how San Francisco's rents or even the Bay Area's rents in general are going down. And that seems to be true from all my landlord clients. That helps us with buyouts because what that does is that basically lowers the differential between what the tenant is paying and what the unit is worth. And the closer the tenant is paying to market, the more likely, the less will generally pay. Also, when the rents for alternate units are less expensive, then tenants are less likely to be resistant to being bought out. And so that I think kind of all affects the pricing of where we're getting. I told you there's no going rate, but what I can tell you is that as compared to, let's say, 2019, I think that the cost of a buyout is less than it used to be for good reasons that I just mentioned. That being said, often when we're doing a buyout, it's under a threat of eviction. And so when there's a threat of eviction, while there's no going rate, there's going to be a floor. I mean, no tenant is going to leave for less than the statutory relocation expenses. So in the case of an Ellis Act, which is a very common threat of eviction, the relocation expense is $10,000. I think it's $10,000 and change, $10,500 up to 3 people. So let's just say in a given unit, there's 3 people. I'm not going to be able to buy them out for less than $33,000. And usually it's going to be quite a bit more than that if I'm going to get them to go voluntarily. So I mentioned also that there are a rescission period. And there are times when we need to somehow get around the rescission period. So the last thing I want to tell you about buyouts is that there are methods of getting around the buyout ordinance that we have. So the most common one is that we do what's called an exempt buyout agreement. The law says that if you settle an unlawful detainer then that is not a buyout agreement and therefore doesn't have to comply with the ordinance. And so what do? We file an unlawful detainer against the tenant by agreement, and then we settle it the next day by pre-agreed terms that everyone's seen and ready to sign. What does that allow us to do? Well, it allows us to avoid the 45-day rescission period. And also we don't have to send a copy of the buyout agreement to the rent board. Why would a tenant agree to that? Well, there are some instances where a tenant wants to move out faster than 45 days. And so this would allow us to do that and pay them all the money without fear of it being rescinded. Also, what it does is it allows us to pay, instead of half on the 46th day, we pay half at the time of signing, and that can be very attractive to tenant. As we explain to them, listen, are you really going to rescind this thing? You know, we've never seen a rescission, and I'm betting you're not really interested in rescinding it. You probably have plans, and wouldn't you prefer to have the money sooner than later? And so if we do that, if we can do a exempt buyout, then we can give you the money, and that's often attractive. So I see there's a question on buyouts, and I'm going to save all our questions for the end, but I will get back to it. But with that, I'm going to turn it over to Adrian, who's going to talk about the statewide rent and eviction control ordinance.
Hello, everybody. Thanks for being here today. So as Jeff just said, I'm going to be talking to you guys about the Tenant Protection Act of 2019. The relevance and importance of the, by the way, I'm referring to it as the TPA for the sake of efficiency, the Tenant Protection Act. The importance of TPA is that TPA provides guidance for no-fault evictions in cities that do not already have localized rent ordinances. So for example, most of you are probably familiar with the Ellis Act and how it is nuanced between Oakland and San Francisco and San Jose, Richmond, Berkeley, and a variety of other cities around the Bay Area in California. So when cities already have local rent ordinances in place, the TPA doesn't apply. But in all other places in California where there are no local rent ordinances, the TPA is in effect. So for example, if you're selling property in Marin County, San Mateo County, parts of Alameda County, Contra Costa, parts of Santa Clara County, then the TPA is what's in effect. And you don't necessarily have the no-fault eviction abilities that you do under cities with rent control ordinances. So for the next few minutes, I'm going to be talking about the different no-fault eviction mechanisms that arise from the TPA. And in doing so, I'm going to contrast them with the no-fault eviction procedures in San Francisco and Oakland. And that's not to confuse you because you can't choose between the two. So I'm not comparing them because you could either choose to go with an eviction method under the TPA or something under a local ordinance, because if there is a local ordinance, then the TPA is irrelevant. So under the TPA, there's 4 types of no-fault eviction. They're almost similar to something that exists in almost every city that does have localized rent ordinances. The first is you can commence a no-fault eviction if you need to demolish the property. The second is that you can have a no-fault eviction if you need to comply with some type of government order or regulation. The building was condemned or some zoning changed and the property can no longer be deemed residential. So now it's going to be commercial. So you can evict people and you don't have to have cause. The last 2 are the more important ones to talk about because they're generally what will be more frequently used for you guys in situations where you're dealing with buying or selling properties that have tenants in them. And those are basically an owner move-in and what we call the off-market eviction is what we'll refer to it as. So first I'm going to talk about the off-market eviction. The rule is extremely simple. If any of you guys have ever looked at any of the local ordinance in San Francisco regarding an Ellis eviction, there's pages and pages of specific nuances and requirements and procedural things that you have to go through. The description of an off-market eviction in the TPA is literally 3 sentences. The main sentence being that you can institute a no-fault eviction if you are trying to remove a property from the rental market. That's all that it says. And then there's a couple of nuances where they talk about notice requirements and relocation expenses. So in contrast, as you know, the Ellis Act under San Francisco is extremely delineated, and ultimately it's very burdensome for owners that are trying to get tenants out of their properties. Before you commence the Ellis eviction, you have to provide disclosures to the rent board. Then you have to provide 180 days notice. You have to provide an opportunity for the tenants to inform you if they are disabled or elderly. In that instance, you have to inform the rent board. That increases the notice period by another 180 days. You have to be aware of the relocation expenses, which I think in San Francisco right now it's 10,160 per tenant, capped at 3,400, something like that per unit, and then an additional $6,000 in change if you have an elderly or disabled person. There's many more other rules, and you guys are probably familiar with them at this point. But my point is that the TPA's version of this, which is basically an off-market rental, has none of those requirements. One of the biggest distinguishing factors and why it is so much easier to commence an off-market eviction under the TPA as opposed to an Ellis eviction under San Francisco's ordinances is that the TPA doesn't require a rent board to be in existence, nor does it require any recording. So in San Francisco, there's a rent board. And as I had mentioned at the beginning, before you even institute an Ellis Act, or an Ellis eviction, you have to provide the rent board with a certain set of information. If there is no rent board to provide that information to, then all of these requirements start to disappear. Most importantly is the lack of a recording aspect. I'll get to that in a second. I'm not getting ahead of myself. So I mean, one of the other primary distinguishing factors of the TPA in an off-market eviction as opposed to an Ellis eviction is the notice requirement. Nearly all no-fault evictions under the TPA just require a 60-day notice. As we've just discussed under the Ellis Act, you have to give 180 days notice, and then if the person makes you aware that they're disabled or elderly, you add another 180 days. So the process is exponentially shorter, which is a good thing for people who are trying to get tenants out of a building. So the main distinguishing factor is the amount of relocation expenses. As I just mentioned, relocation expenses under the Ellis Act can reach upwards of $30,000, $40,000, depending on how many tenants are in the unit and what the qualities and characteristics of those tenants are. The relocation expenses for an off-market eviction under the TPA are 1 month's rent at the time of the notice being provided. So, I mean, you're looking at a dramatic difference in what the payout is. So obviously the TPA is a lot less tenant protective than what you're seeing in local rent ordinances. So, I mean, ultimately, off-market evictions under the TPA are far cheaper and less burdensome than what you would need in an Ellis eviction in San Francisco or under Oakland's laws. The only concern that and I shouldn't even say concern, but something that we have to be aware of when we are working with clients who are pursuing an off-market eviction is the fact that there's no guidance as to use restrictions. So, for example, in San Francisco, when you pursue an Ellis Act, after your tenants are out, you cannot release the building or release any unit in the building for 3 years outright. In years 4 and 5, you can release the building subject to the provision that you have to inform the evicted tenants that you're putting putting units back onto the market, and you have to offer it back to them at the rental price that they were paying at the time that they were evicted. No provision like that exists under the TPA. And so this is the difficulty, is that there's no actual guidance as to what those restrictions are. It's obviously implied that the purpose of the TPA's off-market eviction is that you're taking it off of the rental market. But for how long do you have to keep it off of the rental market? We know that in San Francisco, 3, 5, 10-year rule, but we don't have any of that guidance in relation to the TPA. And again, part of the reason that it's difficult to determine how liability would arise in that instance is because there's no recordation. So again, part of the reason that this is important for you guys is you might have a buyer who's wary because they don't know if they know that there was an off-market eviction, or they don't know there was an off-market eviction, but they're worried that somehow they're going to be held liable for the acts of the previous owner. And the thing is this is different. In this situation, the recordation makes a huge difference, because under the Ellis Act, knowledge would be imputed onto a buyer, because when in San Francisco, when you Ellis a building, it's required that you record the use restrictions, that 3, 5, 10-year rule. So obviously, once something is recorded, it puts the entire world on constructive notice. And in that sense, because a buyer is aware of these use restrictions, if they violate them, they might be held liable. To the contrary, in this instance, because there's no recordation requirement and there is no actual definitive use restriction for an off-market eviction, it's very unlikely that any liability could be imputed into a buyer. So that is to say, we're comfortable with the notion or with the recommendation, or at least it is our belief, that a use restriction wouldn't be imputed onto a buyer. So although a person who commences an off-market eviction obviously has to not lease the property for some amount of time, it's unlikely that that responsibility would be imputed onto a buyer, because the buyer doesn't have notice. So they wouldn't have an obligation to uphold and live in accordance with the use restrictions because they didn't know about them, which is different from San Francisco, where it's forced to be recorded and everybody knows about it. So, I mean, and we've inquired with different jurisdictions as to how this can be interpreted. What are the use restrictions? How long is it that you're not supposed to be able to rent property after you have done an off-market eviction? And we haven't gotten an answer. And part of the reason for that is because there's no case precedent about this. As you may know, when decisions are made by trial courts, they're not binding. Congress makes laws, Congress and the Senate makes laws, and then it's up to the courts to interpret those laws. And then that precedent from those decisions becomes binding on all other lower jurisdictions. But it's only Court of Appeals decisions and Supreme Court decisions that actually have a binding effect. Because all of these cases are so localized, and because the decisions are all based on local nuances and beliefs about the renter and real estate market, the Court of Appeals hasn't actually touched any cases regarding the TPA and off-market evictions. So because there's no precedent guiding us here, it basically gives all superior courts, all the lower courts, a great amount of discretion in deciding how to interpret these rules. And again, that creates a little bit of hesitancy because we're not sure, in the situation, how is a court going to find? Did we put a unit back onto the market too quickly, and did we violate a use restriction? That's hard to say, and it's hard to predict because different courts are going to come out very differently on that. Guarantee that a court in Marin County is going to look at that situation very differently than a court in Modesto. And that's largely based on the fact that they have different socioeconomic situations, different ideologies, so on and so forth, and that's effectuated by the judges and the juries. But in summary, while there's ambiguity there because we're not sure how long the use restriction period lasts, we are comfortable with the notion, and we believe that the liability of any person who violated a use restriction would not impute to a buyer. So in a situation where you have a buyer who's concerned about what might have happened in the past, or whether or not there might be a violation of use restrictions, you can feel confident that it's not going to be imputed to them because they, chances are, do not have notice of any of these things because it's not recorded. So next I'm going to talk a little about owner move-ins. So similar to Ellis evictions in San Francisco, the rules and procedures for owner move-ins are very, very detailed and delineated, and similar to the rule for off-market evictions in the TPA, the owner move-in provision is equally limited. There's just not a lot of information in the TPA. San Francisco's local ordinances, I think it's 37.9 evictions, is literally 30 pages. And that gives us a ton of guidance as to how we have to effectuate OMIs and Ellis evictions. Again, the TPA literally dedicates a few sentences, maybe a couple of paragraphs to each of these things. So there's just not a lot of information about it. But nonetheless, owner move-ins are very easy to effectuate because they have a lot less requirements. For example, in San Francisco, in order to have an owner move-in, if the lease was entered into after 1991, you have to own a 25% interest. And if it's two owners moving in, that to aggregate the 25% interest, it must be either domestic partners or spouses. no requirement like that exists in the TPA. You don't have to have any specific type of ownership interest. Hypothetically, you could own a 1% interest and still commence an owner move-in eviction under the TPA. There's so another example of how the owner move-ins are much more easily effectuated under the TPA is that in San Francisco, you have to, there's requirements like you have to provide, you have to offer any comparable unit to the tenant. You actually also have to provide any non-comparable unit to the tenant. And that's even if it's in a different building. So for example, we're trying to get somebody out of in a 2-unit building in the Sunset, and there's no comparable unit there. But before I actually commence the eviction, I also have to offer them a non-comparable unit that's in a different building across the side of the city. And that's just part of the rent ordinances in San Francisco. Again, nothing like that exists in the TPA. The other aspect that's different is the relocation expenses. Again, the relocation expenses for an owner move-in under the TPA is 1 month's rent. Whereas in the relocation expenses for an OMI under San Francisco ordinances, I think it's $4,500 per tenant, capped at $13,000 per unit, and $3,000 extra if you're elderly, disabled, or you're a family that has minor children living in the house. So it's far cheaper to do an OMI under the TPA than under most other local ordinances. And again, it's not that you can choose between the two, but this is just to describe the nature of the TPA and how much less burdensome it is on owners to effectuate these no-fault eviction processes. So again, I guess another important distinction is that there's no use restrictions. There's no use limitations that arise from an owner move-in in San Francisco. If you have an owner move-in, similar to an Ellis eviction, you cannot rent the building for 3 years. Between years 4 and 5, you can rent it at the rental rate if you give first notice and offer to re-rent the unit to the tenant who was previously evicted. Again, nothing like that exists under an OMI under the TPA. Just, I guess, an important note is that regardless of what method of no-fault eviction you're thinking about commencing, whether it be for demolition purposes, whether it be for substantial rehabilitation, whether it's for an owner move-in, the most effective way and efficient way is to just go about it through an off-market rental eviction. You're taking the unit off the rental market, and it's just more efficient because it doesn't have a lot of the notice requirements that come up in any of the other types of no-fault evictions. So that's my summary of no-fault evictions. I'm going to turn it back over to Jeff.
Thanks, Adrian. So everybody, we're going to tackle one last subject, and then would love to get your questions. There's a Q&A button at the bottom. Please, post any questions you have there, and we'll get through as many of them as we can. The last thing we're going to talk about is eviction moratoriums, which gratefully are over, but there are some little details that are maybe just worth mentioning to you. So San Francisco's ended on June 30th of this year, but they've also instituted, sort of as a replacement for the moratorium, a new defense for non-payment of rent, which is that there's some COVID-related reason why they can't pay their rent. Now, this defense was only good through the end of August, but it did provide another couple of months. And so if, for instance, you have a client who has a tenant who's not paying rent, and the rent non-payment began earlier than August, then this defense could apply. As opposed to a moratorium, though, this is a burden that is placed on the tenant to prove and not the landlord to disprove per se. Just something to be aware of. Alameda County, their moratorium ended on April 29th, but it was subject to local moratoriums, and Oakland, being the largest city in Alameda County, their moratorium didn't end until July 15th. However, that ending of the moratorium also stated that you couldn't begin to do a non-payment of rent eviction unless the rent was unpaid beginning on August 1st of this year going forward. So in other words, there's still a moratorium in Oakland for any unpaid rent before August 1st. You have to go through a civil action to pursue it. If they haven't paid as of August 1st going forward, then we can pursue an unlawful detainer action. However, there is a new rule in Oakland. It's a rule that says that if the tenant's rent is below market, then you cannot begin an unlawful detainer action for non-payment of rent until the total amount of rent equals the fair market value of 1 month's rent. I know what I just said is just terribly confusing, but I have to give you an example. So the city uses basically the pay standard under the Section 8. And so let's just say for the 3-bedroom home that you rent or 3-bedroom apartment that you rent, the pay standard is $3,000. But you're actually renting that place to your tenant for $1,800, and they don't pay you for August. Well, if we filed an unlawful detainer for August, a tenant would have a defense saying, well, I owe $1,800, but the fair market value is $3,000, and that doesn't equal 1 month's rent, and therefore you started this eviction too early, and they could defeat the eviction. We would have to wait until they didn't pay September as well, so where the total amount of unpaid rent was $3,200, exceeding the $3,000 fair market rental value. You don't have to remember what I just said in terms of the detail. You just have to know that Oakland is very messed up, and that's what we have to deal with. So we would love to take your questions now. And so I'm going to turn to the Q&A. And I see from Jennifer, the first question is, what's the purpose of a buyout disclosure? If tenant signs, does this mean they must move forward with the buyout? So Adrian, maybe you can take that question. And you're on mute, by the way.
I'm sorry, were we on the question, what's the purpose of buyout disclosure if a tenant signs?
Correct. That's it.
What is the purpose of buyout disclosure? If the tenant signs, does that mean they must go forward with the buyout? Not necessarily. So there's a 60-day, I believe it's a 60-day rescission period. So after they sign a buyout agreement, there is a period where they are allowed to rescind.
I think, Adrian, what they're asking for is about the disclosure, if I understand the question. But if we serve a disclosure as the buyout ordinances require, that doesn't require the tenant to do a thing. And actually, it doesn't require the landlord to do a thing. All it does is it sort of checks a box that allows you to start talking to the tenant. And I think that's all you should consider it to do. I'm looking at Mark's question. Next question. We sent the buyout disclosure to all tenants, to all tenant occupied properties we sell in San Francisco. Does that need to be filed with the rent board? Well, the buyout ordinance requires that you file a declaration, the owner file a signed declaration. It's a 1-pager saying that I have served the disclosure, or the buyout disclosure on the tenants, and fill in the blanks. That's what is required. The buyout disclosure itself that was maybe signed or not signed by the tenant does not have to be filed with the rent board, but the disclosure does. Let's go to the next question, which, Adrian, you should take this. What does TPA stand for? TPA covers which counties in California? This is from Jen.
Sorry, the TPA stands for the Tenant Protection Act of 2019. And so the TPA applies to all jurisdictions which do not have localized rent ordinances. I actually had a list up just earlier. So cities in California with rent control include Bell Gardens, Berkeley, Beverly Hills, Culver City, East Palo Alto, Fairfax, Hayward, Inglewood, Los Angeles, Los Gatos, Mountain View, Oakland, Palm Springs, Pasadena, Richmond, San Francisco, San Jose, Santa Ana, Santa Monica, and a couple of other places. Anywhere that is not on that list, the TPA applies. The TPA applies in anywhere that doesn't already have local rent ordinances in place. And really, I think there's only 34, 35 cities that actually have local rent ordinances in place. So if you're not on that list, the TPA is applicable.
Great. So Naomi asks, oh, maybe this is an answer. She says they would have notice, though, because we would have to disclose how the unit property has been vacated, right? Well, I think what you're referring to, Naomi, is the fact that in San Francisco, we one of our disclosures that's required by statute is the vacant unit disclosure. And so, I think what you're referring to, Naomi, was what Adrian was mentioning about under the TPA, if you were to use the withdrawal from the rental market grounds for eviction, that a buyer might not have notice of it. But in those jurisdictions, of course, which aren't San Francisco, there would be no vacant unit disclosure. So there would not automatically be notice to the buyer of it, though they certainly could discover or find out about it through the course of the transaction. The next question is from Blakely Hall. For OMI, what if the property is in a family trust? Can anyone from the family who is a beneficiary of the trust do an OMI? The answer is no. It has to be the owner. And so what we would do is we would deed the property, at least 25% of it, into the name of the family member who wants to do it. And that may or may not be possible under the trust. And so obviously that's a very fact-specific kind of situation. This also applies, we get a very similar question where OMI is about property that are held in LLCs and family, corporations. Same thing, corporation, LLC cannot do an OMI. It has to be a human, and therefore we would have to transfer it out. And that can cause issues with estate tax. It can cause issues with property tax reassessment, transfer tax. So it's not a very easy question to answer without detail. Next question from Jen. TPA off-market eviction. What if the seller disclosed to buyer in the disclosure docs that they had an off-market eviction? Would this knowledge affect the usage restriction to the buyer? Thanks for an explanation from Jen. Why don't you take that, Adrian?
All right, so I'm not seeing that question on my list somehow.
Okay, I'm sorry. It's just below Blakely's question. Do you see it? Well, why don't I start off by answering a little bit till you can find it, and you just speak up when you find it. But as I think Adrian explained something that is very hard to explain, which is that there is almost no judicial guidance on what off-market eviction requires, or not requires, excuse me, what it results in. It says that that's what you need as a grounds for eviction, but it then does not thereafter say what happens later. So it was the Ellis Act, which we naturally compare it to. We know what we can and can't do, but because this off-market eviction grounds doesn't have a requirement to how long you keep it off the market, does that mean we can keep it off the market for one day and then re-rent it to somebody else? I would be worried about that if I was representing that client, because I would be concerned that some tenant would sue under some theory of breach of statute or negligence or fraud or something like that. So I think what Adrian said is absolutely right in terms of what our office believes, that problem does not really have much probability of risk to a buyer if it was the seller that did the eviction, because the buyer never claimed that they were taking the unit off the market. The buyer just simply took it in that status and thereafter decided to change the mind, which appears to be what you can do under the statute. Next question from Lisa. TPA doesn't apply to San Francisco, right? Adrian? Yeah.
That is correct. As we discussed, the TPA only applies in jurisdictions that don't have rent control ordinances. San Francisco probably has some of the most robust rent control ordinances in the state. So TPA does not apply in San Francisco.
So Blakely has the next question. When you're repping a seller with a tenant occupied property in rent controlled areas like San Francisco, and the seller wants to sell the property without the tenant for obvious reasons, they will often come to me and say, well, I have a good relationship with tenant. I'm going to let them know that I'm going to sell and ask them if they would be willing to move out. What will you tell this seller or property owner in this situation? I think assuming that if it's in San Francisco, Oakland, the first thing I'm going to tell them is that there's a buyout ordinance. And having a conversation like that without complying with the buyout ordinance violates the buyout ordinance. And if a deal were to be struck, that deal could be rescinded. You know, I've been involved in a number of defense cases where landlords thought they had cut an informal deal, everybody understood, and tenant moved out, and then tenant went to a cocktail party and met some tenant lawyer who said, really, that's illegal, and then there was a suit. So this is about risk management. This, as a landlord, could certainly do what they're describing, work out a deal, tenant moves to, Asia, and you never hear from him again, and it's all fine. But, but what it is there's risks out there. And so if you have a stomach for risks, then you can ignore the law. If you have some concern for risks, then you're going to work on ways of complying with the law to mitigate your risk. Okay, Yubos asks, if I have bought a foreclosure house on trustee sale and there's a tenant living in it, what's the best route to move the tenant out, assuming I'm reselling the home for profit? And I think for this question, we're going to assume it's in a rent controlled jurisdiction. You want to take that, Adrian?
Thank you. About foreclosure. So, I mean, I guess it really depends on what your intention is. So if you're trying to resell the house for profit, then, I mean, your best option would be first to negotiate a buyout, but then to pursue an Ellis Act. I mean, you can't have an owner move in because you're not moving into the property. You're going to be selling it afterwards. So an Ellis Act is the reasonable best option for you. Ultimately, if you're selling the building for profit, especially if you're in San Francisco, there's virtually little to no market for the purchase of rental properties. So once you've Ellised a building, it destroys the nature of the building to the extent that it can no longer be leased for a certain amount of time. But considering that doesn't necessarily make the property any more valuable, an Ellis Act would be the appropriate method. Of course, first instant, trying to initiate a buyout.
I also think the other thing to know is that tenants have full rights on a foreclosed property. In other words, the foreclosure doesn't change any rights that the tenant has. So whether you bought it in a foreclosure or you just had a transaction and you bought it as a regular transaction, what Adrian's saying is exactly the same. The analysis is the same. It could be different if the occupant was the debtor of the foreclosure, which is not what was asked. But if the debtor is the one living there, the one who borrowed the money and foreclosed, that person is not a tenant, and there is a way of evicting that person to get them out. Heather asks, based on the current rules and costs in SF, to accomplish an OMI eviction, how expensive monetarily could it be, and how long would it take to complete, both in the easiest possible and the hardest possible situation? So, Adrian, why don't you answer that question? But let me just say to start with, though, that we almost never talk about the easiest possible way because it just never happens. And it's not super helpful to our clients. In fact, we think it kind of creates unreasonable expectations on their part. But Adrian, please.
Yeah, so again, the relocation expenses for an OMI are that for each person being evicted, you have to pay them $4,500, but that amount is capped at $13,500 per unit. So even if you have 30 tenants living in a unit, it's still capped at $13,500. And then there's also additional relocation payments for tenants who are elderly, disabled, or families that have minor children. So I mean, ultimately, you could be looking at up to 20 grand in the worst possible scenario, 20 grand just in relocation expenses. The attorney's fees for that, might have to defer to Jeff on that, but I mean, it isn't.
Landlord-tenant, right.
Does he represent the landlord more? Or the
He's
tenant?
working for Jeff Wu.
Yeah,
So
so
they're doing a, but they're just,
Hey, he can help us out.
Sorry, we're having some people on the line talking. So I mean, the answer to the question is it could cost up to 20 grand just for relocation expenses. Attorney's fees are going to vary from case to case, obviously, because it depends on the complexity of the matter. The amount of time that it can take. So after an OMI is commenced, the owner has to move in within 3 months. And that's just the code. So I mean, that's ideally the amount of time that it's going to take. There could be complications that arise, but those complications, it's unforeseeable exactly how long that's going to prolong the process.
Yeah, and I mean, the only other thing I'd say is that we typically tell our clients that you should budget $125,000 to deal with a tenant. And that could be either a buyout or an eviction. It's a number that encompasses attorney's fees and money paid to the tenant. That's a budget, and actual cost may be less than half of that. We don't know. The time it takes once the eviction is started, we tell people to budget about 6 months. It could be less than that. It's rarely more than that, but that's just a broad number. So Harold asks, dealing with SF tenant in San Francisco that seems open to move out, what would be a checklist of steps, documents, actions that an owner needs to take in order to start a friendly move out with negotiated money? So, I mean, I think the answer to that question is that there's a buyout ordinance that we have to start complying with. So that means sending a disclosure to the tenant, which owners can do themselves. It's just it's a 6-page form you get from the rent board's website, fill in the blank. So it's not hard to do. Then there's a 1-page disclosure that, a declaration that a landlord has to fill out and email to the rent board. Once that's done, then that's when the solicitation happens. And that's where the work of lawyers like Adrian and I can be useful in terms of strategizing how to do it. I think one of the things that we spend a lot of time thinking through is what is the leverage we have to buy tenants out. The fact that a tenant is open to a buyout is great. That means there's one less barrier that we have to overcome. But it doesn't mean that we can't still have to think through all of our leverage. So obviously one leverage is money. How much is it worth to buy the tenant out? And the other leverage is, are we going to threaten eviction? That's a very important piece of leverage in buyouts if the owner is willing to do the eviction if the buyout fails. But that's sort of the starting point for a buyout. Margaret asks, I'm sorry. Well, yes, Margaret, we are recording this. Anonymous attendee asks, can a tenant declare to, quote, not answer, unquote, on the buyout form, but later come back and claim their age? What do you think, Adrian?
I mean, I think technically you can, but you would probably lose whatever protections you would have had you disclosed it on time. I think it depends on the context of why it is that you're worried about their age.
So I assume that Anonymous is asking us because I think what we're really talking about when you say the buyout form, you talk about the buyout questionnaire, the agreement. And we only care about that for condo conversion. And so so what it really does is by the tenants checking any box but yes, and you apply for condo conversion whenever you qualify, it allows you to sign the affidavit in that form saying, I'm not aware of any buyouts of any protected or disabled tenants. So if the guy later claimed to come back with their age, it's going to be very fact specific as to whether you could sign that declaration saying, I'm not aware that I bought out anyone who was elderly, as an example, and protected because they lived there 10 years. So it's going to be extremely fact specific, and has never come up in my 35 years. Lorraine asks, according to the rent board website, if a unit is for sale, it is all right to give the tenant 24-hour notice to show via phone, as long as within 180 days of tenant being notified of the sale of the unit. What if the unit is on market longer than 120 days? Well, so actually the law is not that it's 120 days from when the unit is listed on the MLS, just to be more specific. And if the unit, sadly, is still on the MLS after 120 days, you can give a new notice and to create another 120 days. All right, we have a question from Karen. Jason Chu, broker. In San Francisco, in SF, tenants have been allowed to add subtenants more freely, up to 3 per bedroom, without approval from the landlord. But my question is more to your presentation. How does the presence of subtenants not approved by the landlord affect what you have stated regarding buyouts, Ellis, TPA, off-market evictions, tenants not wanting to leave? Well, I think Adrian and I will both take parts of this. I mean, with respect, generally speaking, it's almost impossible to prevent a landlord from moving a subtenant, a tenant from moving a subtenant in. If they did move a subtenant in without seeking permission of the landlord, assuming it was required in the lease, then the ordinance requires us to give them a 10-day notice to cure, and that cure is to provide us with a application. So if they provide us the application, they've cured it. And at that point, then you fall into the provisions of the ordinance that talk about tenants seeking subtenants. And it's almost impossible to say no without, unless that person is objectively a danger to others in the building, or the total amount of subtenants would exceed a certain number of persons. Sometimes it's 3 per bedroom, but sometimes it's more. It depends on if there's children or under the age of 14 and so forth. It's complicated. But as it goes to whether it affects buyouts, yes, because everyone who lives in that place has to sign. Does it affect the Ellis Act? Yes, because we would have to name anybody that's there in an eviction. How about TPA and off-market evictions? What do you think about that, Adrian?
It does actually, I don't think that it makes any difference, because in relation to TPA, the only reason that the amount of tenants would have an effect is in relation to relocation expenses, and the relocation expenses of the TPA don't consider the amount of tenants. So I don't think it really has an effect in that regard to off-market evictions in specific.
All right, our next question is from Stephen Huang, our incoming president-elect for SFAR. Congratulations, Stephen. After eviction is completed, tenant moves out, can property be transferred to an LLC where the evictor is the majority owner of the LLC? So generally, the answer is yes. Even if it was an owner move-in eviction, the only requirement is that the person doing the eviction, the owner, lived there for 3 years. So if I did an owner move-in eviction and then the tenant moved out and then I moved in and the next day I sold the building, that is not a violation unless I moved out. So if I sold the building but did a lease back for 3 years, then I am complying with the ordinance, because it doesn't require us to continue to own it. Ellis Act, it doesn't matter, because an Ellis Act can be done by an LLC. And any other kind of eviction, it wouldn't matter either. So yes, it can be done. Next question is there a limitation of time as to how long tenant could sue in a situation described where informal agreement was entered into? You have some thoughts on that, Adrian, in terms of statute of limitations?
Statute of limitations for breach of contract is 4 years. Assuming that we're talking about a binding contract, you'd have 4 years to bring that suit. I'm not sure if there's a specific nuance in relation to buyouts.
Yeah, I don't think so. And if it's an informal agreement, which was oral, then it might be only a 2-year statute. There's arguably a 3-year statute that might apply for violation of statute that they might argue that there was never an agreement. In fact, that's what they're going to argue, that there was never an agreement and you lied to me, it's fraud. So I would say a 3-year statute or 1 year from discovery is what I would be working with myself. Anna asks, is there a form for the declaration or does it need to be drafted? Oh, I'm sorry, form. If you're talking about the buyout declaration, these are rent board forms. So you go to the rent board's website, you can search the term buyout and you can probably find the two forms, the disclosure and declaration. Michael Bellings asks, remind me, if you Ellis Act, within 5 years, you have to ask past tenants for past rent rate and 10 years until you have rented out to new people. So Adrian, why don't you take that one?
Yeah, so the rule is that for the first 3 years after an Ellis Act, you cannot evict anybody. For years 4 and 5, so long as the previous tenant has informed the rent board of where its current address is, if you're going to put the unit back onto the market, you have to first offer it to that tenant at the rate that they were paying at the time that they were evicted. If the tenant doesn't provide any notice to the rent board of their address, you actually don't have to offer it first and back before you try to put it onto the market. In the 6th to 10th years, you still have to offer it back to the evicted tenant, so long as their information has been provided to the rent board, but you can then rent it to them at the fair market rate. If you either do not have to inform the tenant or the tenant does not want to take you up on your offer to retake possession of the unit, then you can put it back onto the market with anybody. But in those years 4 to 5, it still has to be at the rate that the previous tenant was paying when they were evicted. But after years 6 through 10, you're able to charge the market rate.
Great. So we're past noon, but I think unless Genevieve wants to kick us off, we'll just try to answer the remaining questions as quickly as we can. Roger asks, what are the repercussions if a tenant won't allow a showing for an open house or broker's tour? State law allows you to enter premises with a notice, and if they refuse to allow entry, then that's a grounds for eviction. And we could theoretically serve a 3-day notice to perform covenant or quit. It's not the best way to have a relationship with a tenant and in a property you're trying to show. And so, like I have counseled many realtors, honey is better than vinegar here, and the threat of eviction is not ideal. But ultimately, that's where it would land. Next question is from Rob. Can a tenant rent rooms out short-term 90 days at a time? So I think I'll take that question. So you don't, hopefully if you're using the SFAA lease, that would not be allowed anyway. But if a tenant is renting short-term more than 30 days, there's an argument that violates still, even though it doesn't violate the short-term rental law, there is a new law that passed that applies to landlords too, that the initial term of a lease for a tenant and presumably a subtenant is 1 year. And so that may be a violation of law that we might be able to pursue. It hasn't come across my desk yet as a case, so I've never dealt with it, but that may be the way that we could leverage a tenant to stop doing that. Nadia asks, vacant unit disclosure due to a buyout on one of 2 units was provided to purchasers when marketing the property. Apparently, the tenant was a teacher with a child. Buyer who purchased the 2-unit building are not aware of any protected tenants. Will the buyer be able to apply for condo conversion after 1 year occupancy? Well, so assuming that buyer moves into the now vacant unit, they would not qualify for condo conversion until they won the lottery, because in a 2-unit building, both units have to be owner occupied for 1 year to qualify for conversion. If the lottery came back, then occupying one of 2 units would qualify them for the lottery if they lived there for at least 3 years, assuming the lottery comes back next year. So that's a question that we're going to have to ask Mary Jung and Jay Cheng, because that's crystal ball stuff. But in and of itself, the buyout does not seem to have a problem, assuming the tenant did not check yes to the question of, am I a protected or disabled tenant? The question doesn't ask whether I'm a school employee. Rob asks, are you able to add 18-year-old child to title and OMI a protected tenant? And if so, what's the downside? You want to try that one, Adrian?
Sure. So I believe that an owner has to have lived in the property for over a year before they can do an OMI in San Francisco. Is that accurate, Jeff?
Actually, I don't know. So
I think that there's a requirement for how long you've lived at the property before you can do an OMI. So there might be a issue there. But I mean, the only other thing that pops up is that you have to be a 25% interest owner. So if you're going to add your child to the title, you have to make sure that you give them over 25% interest, 25 or more percent interest. Otherwise, they wouldn't be able to effectuate an owner move-in.
yeah, there's also a downside for tax reasons. I mean, transferring a title to your child, whatever percentage, if you've held it a long time, they're gonna lose the step up in basis if they were gonna inherit it anyway. Jason Chu, as a follow-up in negotiations, usually buyouts would be per tenant, and suddenly where my client was unaware of subtenants, there are now magically protected tenants, children, additional subtenants. Well, when we negotiate buyouts, we negotiate for units, not per tenant. That's typical. And it's not untypical to have people coming out of the woodwork. And our position is we're only buying out everybody with one lump sum or nobody. Because if we're going to have to evict you, we're not going to buy out some and evict the other. So there isn't much that you can really do about it, unfortunately. And this is one of the welcome to San Francisco kind of things that happens to landlords. Harold asks, are the rules modified in dealing with a tenant who rented a room only, not entire house? In this case, the tenant rented a room in a house, in a home, and with the other rooms being rented to other tenants. The other tenant left, and since then, the remaining tenant has in effect taken over the entire house. Does this change anything in handling of the buyout ordinance? Well, in terms of that discrete question, the answer is no. But I mean, your question highlights the problem with renting room by room, and it happens in San Francisco. And there are good reasons that people do it for financial reasons, but there's a huge risk, and Harold, have described one where if it wasn't a buyout situation, it was just like the tenant was, let's say, preventing the landlord from showing the place and trying to get another roommate, or maybe another roommate is brought in and the other roommate tortures that roommate, through terrible conduct. I've had all these situations, and it's a very difficult situation, so it's never recommended. But just in terms of a buyout, if it's a 2-bedroom house and only one is rented and you're trying to buy out the one tenant, it's actually a better situation, because the less people that you have to deal with in the buyout, the better. So my last two questions, the last question really is from Roger. How much do you charge for your representation? My rate is $600 an hour. Adrian's rate is $435, I believe, something like that. And I'm happy to talk with you or your clients in more detail about budgets and so forth. Adrian and I would really like to thank all of you for coming and for your great questions. We hope that it's been informative to you. Please feel free to reach out to either of us if you have follow-up questions. Hopefully you got the handout that Genevieve, I believe, forwarded to you, which has both Adrian and my direct line and our emails. And we'd love to hear from you. And so again, thank you so much. Have a great day.
Everybody.